May please, your Lordship.
Oh.
Lordship, for item number 14, in the daily list, we had filed a affidavit in opposition on last Friday,
Oh.
but the same has not placed on record. Lordship may kindly direct the registry to place it on record.
Let it reach. Yeah. Call for the records.
Highly blessed.
You give us the few copies.
Okay. Lordship.
May I please, your Lordship? My lord, I beg to mention for listing open, my lord, writ petition. My lord, here we are challenging, my lord, Alga Pirates.
Petition.
Writ petition. There is some urgency, my lord, on Thursday, my lord. The similar matter has been posted on tomorrow, my lord. Some other petitioners has filed. That is as regards to the, my lord, we are challenging the, my lord, draft of delimited constituency wise. That, my lord, and ultra virus of, my lord, MSC Act 2020.
Is it listed tomorrow?
He wants it to, the other matters are listed on Friday, Thursday.
My lord, Tuesday, my lord.
Huh?
Tuesday.
Tomorrow, all the matters are listed tomorrow.
Tomorrow, my lord.
So when do you want?
Tomorrow.
My pleasure, Lordship. Lordship, it's a prayer for listing, my lord. Repetition we have filed under surface, my lord. 13 application notice has been issued, my lord. Maybe before vacation, any date, my lord. Before vacation, my lord.
Okay.
Let it come up after the vacation.
My lord,
There's
13
nothing-
notice has been issued, my lord. Anytime position may be taken.
DRT.
You have to
My
go
lord-
before the DRT.
My lord, there is an issue, my lord. There is an insurance cover in the loan amount, and that has been repudiated, my lord. Illegally repudiated. That's why, my lord. There is an urgency, my lord.
Thursday.
Lordship,
Matlab.
I filed read appeal.
Oh.
Some urgency is there. So Thursday, it may be there.
May it please your lordship. My lord, I beg to mention item number 17 of today's list, my lord. I'm led by my lord, senior advocate, Mr. K. N. Sodari, out of station, my lord.
Okay.
Later may come up after vacation, my lord.
Okay.
I am there for the response number 1, Lordship. This
No
is-
orders passed, Mr. Goswami.
My lord.
No orders passed.
No,
by-
my lord.
Lordship, today a mention was made by the counsel for the applicant and honorable court expressed that it will be pronounced tomorrow, Lordship. Tomorrow. It has otherwise become
Infractions.
No, my lord, after my lord vacation, my lord, after my lord, maybe fix after the day after tomorrow, my lord.
No, what can we do here?
My lord, since my lord, I'm led by Mr. K. N. Sodari,
No,
senior advocate, that is why my lord,
what
I'm not,
happened?
my lord.
Just on your services.
parallel, Lordship.
Oh,
No, they have passed their.
okay.
My lord, may I pray, my lord, maybe fix the day after tomorrow, my lord. Mr. K. N. Sodari
Okay,
will come.
okay. Day after tomorrow.
My lord.
Okay, on request made on behalf of Mr. Ken Jawad, the senior counsel for the petition, for the petitioner. You want it on Thursday?
Well.
List the matter on. Right.
May I please your lordship? I'm appearing for item number 15. Lordship, UKNIS may not like to take up this.
Okay, list this case
15.
before any other bench without one of us. Even better, justice, you can. 16 also same matter, I think. 16,
May it please, your lordship.
item 16. Anybody appearing for item 16?
Yes, sir.
He also, he can't take up.
15 and
Brother,
16.
same model.
He's coming.
It will be difficult to fix a date with you.
Someone else would have appeared in my place if you had not become a judge.
16.
No, I left it midway.
You are appearing, Shama?
16, yes, your lordship.
My brother.
yes.
May it please, your lordship. My lord, I may be allowed to move an urgent writ appeal tomorrow, my lord. The urgency is that, my lord, there was a tender wherein I was declared L1, and the technical bit of the petitioner, it was rejected. And the learned single judge has interfered with the minutes by which the technical bit of the petitioner was rejected. And if that decision is acted upon by the state, my lord, then I'll be nowhere, my lord. So kindly, my lord, tomorrow.
Thursday.
Tomorrow, my lord. There is some urgency, my lord. In the meantime, Wednesday, my lord, and there is.
Witness is a holiday for everybody.
My lord, I may remain out of station, so that's why. If not inconvenient to your lordships, my lord, tomorrow,
We'll have it on Thursday.
Thursday.
Lordship, I'm
I live.
going for listing of fresh writ appeal, Lordship, on Thursday.
Your lordship, I beg to mention a writ appeal for urgent listing tomorrow. your lordships. It's a tender matter. There was an interim stay which was vacated by the orders of this honorable, of the learned single judge on 17th of September. And we filed it on the 25th. Your lordships may take it up tomorrow if permissible. Oblige, your lordship.
My lord, I pray for listing of this matter for hearing, my lord, last listed in January 2024.
This is a motion week,
No, not this week, my lord, after vacation, my lord.
okay, after vacation.
On 22nd, my lord, it's a hearing day, my lord.
22nd will be quite bad.
Or on 7th of November, my lord, it's a hearing day, my lord.
Yeah, so make it 7th of March.
Item 1 of daily order.
As per record, notice has not returned on the private respondent. Lordship,
When was the notice sent?
notice is sent by registered post with AD.
It was issued on.
I think it is served, Lordship.
23/7. Maybe
It
you
can
want
be
to
presumed to be
take,
served because
cannot be presumed to be served when AD card has not. If you want, you can take fresh steps.
court process, Lordship. By usual process,
But I registered post AD.
by usual process.
Mr. S K Goswami.
In this case, so far as from number 2 is concerned, my lord, the commissioner in the commissioner Lower Assam division, divisional commissioner is abolished, my lord. That strike off, my lord, as per number 2.
But we can't strike off. You'll have to
Who
file
does
an
it?
application.
The divisional commissioner.
Okay, Mr. S K Goswami, learn the council for the application.
Principal secretary.
It's allowed 1 week time to take first steps for service of notice on the respondent number. By registered post AD as well as by user service. This after
For respond number 1,
for Mr. A Fukan, standing council,
General Administration Department.
GAD appears for the respondent. List of
Published.
for which?
After application,
Yeah.
To
This is rigid.
24 the office note. My lord, we'll find the office note, my lord, dated 24th September. My lord, the AD card has not received from the respondent.
How
and
about the Dusty affidavit?
Thusly also we have taken on my lord 8, but we couldn't file the affidavit because the receipt we couldn't collect from Silchar, my lord. It was served at Silchar. So we'll be filing the affidavit, my lord. It is served otherwise.
Okay, Mr. B K Royal and the senior counsel. For the appellant, substance that Dusty service was taken
On 8th of,
on 8th of
8th of August, my lord.
8th of August 2024 on the respondent numbers 1. And he plays for 1 week time or 2 weeks?
Let it come after the
So we'll give you 2 weeks.
2 weeks, lord.
Praise for 2 weeks time. To file an affidavit to that effect. Praise the Lord. List of 2.
And the register, it may await service report on the register post. There is a fees note, my lord.
You file your affidavit in the
Lodge.
meantime, we pass you.
admission.
May I please, your lord.
Thank you.
Yes,
My lord. My lord, here in this case, departmental proceeding was initiated during the service and penalty was imposed, concluded before service, before retirement, my lord.
Penalty was imposed
Imposed
before
even
retirement
before
or-
retirement, my lord. But the penalty in that case, my lord, has been imposed are that pension limited to up to 50% and whole DCRG has been withdrawn, which cannot be done, my lord, as per 7, my lord. Now, the learned single judge has exceeded its jurisdiction and that disciplinary proceeding was converted to Rule 21 of Assam Service Pension Rule, my lord, 1969. That also cannot be done. Because
The pension.
Rule 20.
pension from the other. Here, my lord, the governor of Assam reserves himself the right of withholding or withdrawing a pension, my lord.
21A.
Yes,
21.
21, my lord.
And what is 21C?
21C is regarding judicial proceeding, my lord.
Okay. Yes.
My lord. Now, here in Rule 21, basically, whenever a person is in service and he is continuing service and departmental proceeding is continuing till his retirement, then Rule 21 will apply. But already penalty has been imposed. That means the departmental proceeding has been concluded before retirement, my lord. No question of applying this Rule 21 itself, my lord. And Honorable Learned Single Judge has converted it to Rule 21, my lord.
See, proceeding was started, then concluded.
Penalty was interfered. Then the Supreme said that
Proceeding. This one says something else. Yeah. Okay. Hurt Mr.
BM recommended.
BM the color. What happened? Human beings. Mr. Dinath, Leonard, Senior Governor. Enters appearance on behalf of all the respondents.
1, 2, and 4.
Okay, 1, 2, and 3.
1, 2, and 4.
And how 1, 2, and
4.
4.
Finance is respondent 3.
And finance?
Lordship may record the name of Mr. P. Nayak. I'll
Mr.
inform you.
P. Nayak, Leonard, Standing Council Finance, appears to the respondent. So, you want to hear the matter today or?
Lord, it has come for the first time. Lord, I'll only one thing, Lord, I have to take the information because the learned court single judge has given us the liberty. Has given us the liberty, Lord. What happened thereafter, I have to take that information.
Dinath, Leonard, Senior Governor Advocate. List the matter after the puja vacation.
Puja vacation.
And my lord, for the time being, my lord, full pension may be allowed, my lord.
As my pension has been limited to 50%, my lord.
No, is it coming up for the first time?
It has come for the first time.
Oh, no, I think there was an IA.
It was for condonation of
Okay,
delay and that has
delay
been condoned.
Delays.
My lord, for time being, my lord, for interim, my lord, pension, full pension may be allowed, my lord.
No, no,
Because it has been limited to 50%. Now I am getting only 50%.
Prayer for entry shall be
Not at this stage.
considered on the next week.
Lodged.
That's all right.
Four.
Maybe. No, this is regarding Muslim marriage dissolution, my lord. And earlier similar cases pending, my lord, some cases. So not that the matter may be taken with that matter. That number is, my lord, 3968.
Well, there are series of cases and we have filed affidavit in opposition all those cases, my lord. These cases are fixed after vacation.
Okay.
And the
Then
leading case
cases
is my lord WPC number 259624.
3968 was one of them.
2596.
3968 last number. There are several
This is the
cases.
first case, my
Anyway,
lord, wherein
this
we
is-
have filed the affidavit.
Then we issue notice here.
My
my
lord.
lord.
Heard Mr. A. Roshit, learning counsel for the petition. Issue notice. You are appearing for?
My lord, 1, 2, 3, and
What
5.
was his name? DK Bora, DK Beach, DK Shah. Mr. DK Shamal and additional senior governor. Appears on behalf of respondents.
1, 2, 3, and 5.
3, 5. 4. Revenue?
Standing Council Revenue Department, my lord. My lord, name of the J. Hendrik may be recorded.
Mr. J. Hendrik, Leonard Standing Council Revenue appears for the respondent. Notice on respondents are complaint. You want extra copies?
Yes.
All the extra copies, so respondents are allowed to fill up. List the matter after the puja vacation along with WBC 2596 of.
And other connected cases.
Utmost.
Mr. Sharma, you're not raising a maintainability issue in this case.
Yes.
He's a private
Yes.
organization. You're not raised.
You've raised in that other matters.
My lord,
Others-
because
that's a
a
complex.
series of
Okay.
cases are pending, that is why my lord. I have not raised today, my lord.
5.
PIL.
Lordship. Lordship, in this case, Lordship, a scheme was sanctioned, Lordship, for construction of a road cum dike, Lordship, for protection of the people from flood and river erosion, Lordship. And accordingly, Lordship, the work has been started, Lordship, and there are two categories of work, Lordship. One is, Lordship, geobag protection work, Lordship, in the edge of the river, Lordship. And another is, Lordship, construction of the road cum dike, Lordship. In the meantime, Lordship, it is a big project, Lordship, and in the meantime, Lordship, some of the petitioners approached before the Honorable Court, Lordship, for apprehension of their apprehending their homelessness, Lordship. Because no land acquisition process was initiated, Lordship, and as such, Lordship, the Honorable Court passed an order, Lordship.
So that writ petition is still pending, isn't it?
Yes, Lordship. And here, Lordship, the geobag protection work, Lordship, which was started in the edge of the river, Lordship, some anomalies, Lordship, found, Lordship. And Lordship, it is after about, Lordship, 100 years of, Lordship, earlier construction of road, Lordship, the scheme was sanctioned, Lordship. And if, Lordship, not properly implemented the scheme, Lordship, the people will suffer, Lordship.
Dekha.
Lordship, this is not a public interest litigation, Lordship. This is in fact a public interest litigation. Petitioner had earlier filed a writ petition, Lordship. It is before your Lordship. Lordship, may kindly go.
I disclose this fact, Lordship, in this petition, Lordship.
Petitioner's name.
Same petitioner.
Same petitioner.
No, no, Lordship.
Same petitioner. Petitioner's name is reflected in number 15, Lordship. I have highlighted, Lordship.
Who's the petitioner here?
Noor Hussain Loscar.
Noor Hussain Loscar.
Number 15, Lordship. Father's name same.
Yes.
Lordship, this way and that way, Lordship, public are affected, Lordship.
What is that
With-
there in the other writ petition?
That writ petition, lordship, not to disturb their land. They claim that their land belongs to Patta land. And over that land, a dike was proposed to be constructed. Against that construction of dike, because they need that, means they wanted the land acquisition, means land compensation from the respective department, that is from the Water Resource Department, lordship. Same cause of action, lordship, same scheme, same project, same everything, including the petitioner is also the same, lordship.
What about this prayer 3,
Lordship,
prayer number 3, Roman 3? Is this the same prayer in that writ petition?
lordship, they want the land compensation, lordship.
That's why,
That same, lordship.
same prayer.
Here they have admitted, Lordship, land acquisition was not initiated, Lordship. But Lordship, under the garb of this petition, Lordship, the authority is now sitting, Lordship, and 3 times, Lordship, people are affected, Lordship. In this year, Lordship. Flood affected, Lordship.
See, you are a writ petitioner in that writ petition, particular writ petition,
Yes,
WBC number
180, 2024.
180 of 2024.
Lordship, so for that reason, Lordship, some instruction is required, Lordship. Whether this person is same or not, Lordship, it is the question.
Same, give him a copy.
Lordship, he himself knows, lordship, because my learned friend had filed that case, lordship.
Oh, is it?
Yes, lordship. Lordship may go
Yes,
to
Lordship, I am also
the
there.
advocate for the petitioner.
Who is
P.U.
there?
Laskar.
P.U. Laskar.
Their grievances, Lordship, under the garb of this petition, Lordship.
Mr. Laskar,
Yes, Lordship.
first you said you wanted to take instructions whether the petitioner had filed a writ petition or not.
Yes, Lordship.
And you were the counsel there.
Yes.
Now you are trying to change your
No,
argument.
Lordship, within the same area, Lordship, all the people are within the same area, Lordship. They have admitted this, Lordship, the individuals,
Yeah.
here, Lordship, for apprehension of their homelessness, Lordship, the people will suffer, Lordship, for if the implementation of big
Yeah, tell-
project is implemented, Lordship.
Mr. Laskar, you have gone there for land acquisition.
Yes, yes.
At the process. Now the government has also said that the dike will be going over, they'll take over the land. You are no longer there. You will no longer be there if the government takes over. So this prayer number 3 is clashing with your writ petition. Why have you made 2 prayers in 2 different forms? Is it permissible?
No, Lordship.
Withdraw this, file it in a better manner.
Sorry, Lordship. Yes, Lordship.
Mr. B.U. Laskar and a counsel for the petitioner. Press for withdrawal of this PI. With liberty or without liberty?
With liberty, if some other person will come, Lordship.
With liberty to file a petition. Stop, Mr. Your
RM Das. RM.
RM Das.
3 and 4.
Okay, you are for?
Two and four.
What's his name?
3 and 5, and us, 3 and
And Das, Leonard, Leonard, government advocate.
government, 3 and 5.
Appears for
3 and 5.
3 and 5. Yes,
R1, my lord.
and Mr. Babu Jari, Leonard, standing counsel, reviewing appeals for respondent number 1. And you are for
2 and 4, lordship.
2 and 4. R Das,
RM Das.
RM Das, Leonard, standing counsel,
Water.
Water Resources Department, appeals for respondents 2 and 4. PI is dismissed. Withdraw with liberty aspect.
Public.
6.
The first he says he wants to take instructions. So then he does.
May I please?
Yes.
My lord, I have preferred this writ petition against the order of the Central Administrative Tribunal.
Oh, where's the
The-
order?
Page 122 is the order. my-
Oh.
Order dated 22/5/2004, my lord.
But Mr. D.K. Sharma, then counsel for the petition. Issue notice. Union, who is that?
I am appearing.
Mr. K. Parasar, K. Parasar, then CG appears for the respondents,
All the respondents.
appears on behalf of all the respondents. You want to file affidavit?
Maladies.
You want to file? And praise for, how much time?
3 weeks, man.
3 weeks time. Praise Allah. List of blacks.
19 of supplementary list.
What is like?
May I have your lordship? My lord, we have challenged certain portions of the amendment made section 24 and 25 of CRPC.
Yes, man.
My lord, I am the public prosecutor in the Sessions Judges Court at Kokrajhar. And I have been appointed on 12/6/2002. That is 22 years of as public prosecutor. I am working.
Can issue notice? That's Mr. M.U. Mahmood, Learned Counsel for the petition. Issue notice. Anybody respond? Mr. D.K. Sharma, Learned Additional Senior Government.
My submission, my lord,
Enters appearance on behalf of all the respondents. And place for how much time? 4 weeks? 4 weeks time to file affidavit. Praise the Lord. List of the 4 weeks. You furnish extra copies?
Yes, my lord. My lord, may I pay one thing, my lord? Till they submit affidavit, I may not be disturbed, my lord.
No, sorry.
Because there are some citations of the Honorable Apex Court, my lord. I have brought some citations.
After 4 weeks, you'll be.
It is said, my lord, it is indirect discrimination and that should not be. My lord, only one judgment lordship I may.
whatever, my lord, the petitioner wants, man, that is already in the rules, my lord. Rules, my lord, page 20, rule 5.
File your affidavit.
7 of Delhi list.
My lord, I have finally replied.
May I please your lordship, kindly this matter may be taken after puja vacation. Mr. KL is not here, he is out of station.
Yes.
My lord, regarding great pay. My lord, he is now a senior Hindi translator. He should get his great pay as 4,600. My lord, similarly situated cases
And in my affidavit, page 44. One PP, that Junior Indian Raka, she got the great pay at MSP in rupees 4,600. And
Anyway, since KL is not there, we'll list it after the puja.
Yes.
Only first made on behalf of SCKL, then it comes for the petitioners. List after the puja.
Much obliged. Humble prayer with due apology, my lord. My interim time may be considered on the next reasonable date. That may kindly be observed, madam. I have good case. I have so many citations of the Honorable Supreme Court.
Have you checked up the documents that you have annexed in the writ petition?
Yes, that is my read petition. Only may be considered, your lordship may not.
Because of that,
May it be
because-
positive, may it be negative.
Because of that, we did not consider you interim, particularly going through your affidavit. And rule 25 plus your affidavit.
8.
Your lordship, in this case, I have been instructed by Mr. A.K. Prakash Rao. They have filed affidavit, your lordship. I want to file a rejoinder again.
Affidavit.
Yes, by respondent number 1 and 2. So he would like to file a reply, your lordship.
Affidavit was filed in September 2023.
Whatever,
Anyway,
maybe I have been instructed.
Let
you.
them file, we have no difficulty. Whenever they want to file.
Okay.
You're appealing for absence or for statement?
Petition.
Okay.
Yes, how much time?
2 weeks or after vacation, your lordship.
Your good name, please?
Any day in the month of November, your lordship.
Okay, on request made on behalf of A.K. Purgas, then a counsel for the petitioner. 2 weeks time is allowed to file reply to the counter filed by the respondents, 1 and list after 2 weeks. Mr. P.K. Dewari, the senior counsel.
For state.
Appears on behalf of the,
State, my lord. I am appealing for the state. Appealing a special, yes, my lord.
okay, appears on behalf of the state of
Arunachal
Arunachal.
I don't know, my lord, what will come in this case because mandamus can't be issued. To directing the state to grant permanent residence certificate.
Yes.
On a BSTs. Very difficult. Anyway, be that as it may, whatever.
They are not FPPs.
They are not.
They are not FPs.
They are not. Ahom, Moram, Theories.
They are not FPs. But what about the unaccused people there? Are they given a
Yes, it's
PRC certificate?
They are not entitled, the PRC certificate only for the purpose of education and all that, for the admission in colleges and all, for limited purpose. But I believe the purpose for which they want it, that is why the whole difficulty. That is,
yes.
I don't know. That is why not even the APSU has come into the picture. They have got themselves included here.
That it will be for purposes other than recognizing them as an APST tribe. I think that-
Let us see, Milord, because there is also a recommendation of the joint high-powered committee.
Committee was.
And then there was a cabinet decision. What they want is they want earlier cabinet decision to be acted upon. So then naturally.
9.
Item 9, your lordship.
But I have received the status report today. As per that status report, they said that it will be completed by 30th of 11. Lordship has directed us to file an affidavit to that effect. Kindly give me some time, I'll bring that.
Okay, Mr. D. Nath, the senior government advocate, submits that he has received the status report
I have received it today.
in terms of the order dated 13/9/2024. No, he has received the status report today. Stop and praise for how much time?
Give me 1 week time, it will be come up.
Praise for which
reapply.
time to file the same? By way of, to bring the said status report
It will be served.
by way of
after
an
3
affidavit.
weeks. Puja is there.
List after the puja vacation.
Lordship.
Remainder, your lordship, I have also obtained GPS photographs
That
of
will-
this month.
We'll see.
No, I have to go by the report.
Right, yellow.
10,
May I please, your lordship? For the respondent number 3, your lordship.
Respondent number?
3, your lordship.
Oh.
Upen Kalita, your lordship.
Hmm.
Kindly give me 5 weeks time to file my affidavit, your lordship.
5 weeks.
5 weeks time.
Why?
The Upen Kalita respondent number 3 is on and off going outside for a medical reason, your lordship. He will be back and I will be able to take his instructions in the week.
We'll give you 3 weeks time.
So 4 weeks.
Okay, your good name, please?
P Das, your lordship.
MSB Das, Learned Counsel, appearing on behalf of the respondent number 3. Is allowed 4 weeks time to file affidavit. This after 4 weeks.
No. Puro ka na po na. Kuha ka.
I appear for respondent number 4. We'll give her time.
Last time it took time, my lord, to filing affidavit.
You had given up the challenge. Yes. How are you again challenging that same very thing in the writ appeal? You have given up the challenge. There is a categorical paragraph to that.
Let them file a reply, my lord.
Why? You have given, see your statement. Para page 63, para 3. And you have not taken any ground that this was not in your master.
The kindly page number 62.
63, you need. Page 63, para 3.
Only for the response of 4, my lord. It's just one person.
You have given up, and again you have challenged this in very.
Next, your lordship.
11.
May I please, lordship? When I was filed seeking substitution, actually appellant expired recently. It is not yet probably annexed and the appeal.
Copy is also not served upon us.
It is already in the process. It was filed on 27/9 recently. 27/9.
IA number?
I actually, it is not numbered actually. It is filed on 27/9 recently. Appellant has expired also, seeking substitution.
No.
Maybe listed after 3 weeks. In the meantime, it may be annexed probably.
Okay.
But copy is not served to us.
Copy is already furnished, Your Honor, and
Okay.
registered.
Mr.
H.K. Sharma.
HK Sharma, Learned Counsel for the applicant submits that the heirs of that the applicant expired on
Expired on 4th of August this
4th
year.
4th of August
This year.
2024, and the heirs of the applicant has filed in IA for substitution.
Substitution is heirs.
Registry to verify and place the same on record. And
After
list the
vacation
letter
may
of
be
the-
listed here.
12,
My lord, in this case, affidavit has been prepared, it has gone for vetting, my lord. Let it come after vacation, my lord. I don't know what I did last time.
Yes.
Yeah, please, Your Lordship. Lordship, the respondents were, in the last day, the respondents were. they-
Maybe
asked
there's no need to file an affidavit.
But it is gone for vetting, my lord. No, moreover, it can be taken up, my lord. The law is very clear. 3G, my lord.
Anyway, you're not prepared.
Lordship,
Okay, her senior is not done. You want to file your affidavit or not?
Okay, anyway, it will go on. my-
Okay,
and-
Mr.
And thus, my lord.
And thus.
8, 9, 10.
Government advocate, appearing for the respondents, 8, 9, and 10. Place for how much time?
Let it after vacation.
Place for 3 weeks,
No, no,
2
3
weeks,
weeks, 2 weeks enough.
2 weeks time to file affidavit. Place or not, list of the puja because. Tell your senior to go to this 3G.
13.
But this is the one where affidavit was posted.
May please your lordship. My lord, an IA was filed, but in the meantime, certain developments have taken place. Pursuant to your lordship's earlier order. What happened, my lord? The petitioner, appellant before your lordship, he was working in a, my lord, the suspension vacancy as a driver. Then, my lord, there was an advertisement for the post of peon in the labor court. And he was selected and he was, although he was selected as peon, he was appointed as a driver. And my lord, that was in 2006 and he continued as such till my lord 2014. Then my lord, what happened in the meantime, the person who was under suspension, he approached this honorable court and he was reinstated in service. And therefore, my lord, I was reverted back to the my lord post of peon in 2014. And my lord, he was given that post. And the person, my lord, whose post I was given, my lord, he has been transferred to some other post, my lord. He was duly protected. The case, my lord, before your lordship is that, my lord, the authority issued an order, my lord, directing that, my lord, I should be reverted back, and my lord, he as peon, and that, my lord, the amount I have received in excess that should be recovered. Against that, I approached the honorable single judge, my lord. Single judge held that recovery is not permissible, but you'll have to go back as peon, and the salary will be fixed with effect from 2006. So I was agreed by that part because, my lord, I have rendered service from 2006 to 2014 as a driver. And my lord, that protection I must have, that is one aspect. And that, my lord, if I'm reverted back to the peon without the, my lord, protection of pay, then it eventually affects, my lord, my pension and entire career. But the question here is, my lord, when I was appointed, my lord, I was initially I was working as a, my lord, driver, but advertisement was for peon, and my lord, they appointed me as a driver. That may be a mistake, my lord. My lord, I should not be made to suffer because of that, my lord. No action has been taken by the authority against the authorities who appointed me as driver. Now, my lord, fine, I was, my lord, selected as a peon. I work as a peon, but my lord, that protection, pay protection, of course, the honorable single judge has said that, my lord, no recovery has to be made. But, my lord, fixation has to be done from 2006. My prayer is before lordship is that, my lord, that fixation has to be from 2014, my lord, when I was given the post of peon. That is my case before your lordship. Now, what happened, my lord, after we filed the petition, I got, my lord, salary, previous salary up to July, my lord. From July, my lord, it was not paid. The moment,
July of which year?
The 2024. Then, my lord, this honorable court passed an order on 28th of August.
Yes.
Then, my lord, for my lord, making some payment. Now, my lord, they have done the refixation and paid me at the scale of peon, my lord, which is much below that then I am, my lord, receiving. Salary money reduces salary reduces. Not an instruction on how many seconds.
Salary is required to have like appointing authority is the judicial department or president.
You have complied with whatever you have said.
Yes.
My lord, on the last occasion on 28/8/24, my lord, this honorable court, while my lord pressing for the interim order, the honorable court refused to, my lord, grant the interim order and instructed me to pay the salary after refixation within a period of 3 weeks. I have took time for that, my lord. My instruction from the judicial department said, my lord, the appointing authority is the presiding officer, labor court, who represent, my lord, my learned friends.
The learned senior counsel has made a submission that already salary has been released. I don't have definite instruction, my lord. That means the pay fixation has been done in the post of peon. So
That is with
nothing
effect from-
survives in the writ appeal. my lord.
That is with effect from 2006.
Lord, with effect from 2006.
My claim is that, my lord, it has to be from 2014, my lord, because I have rendered my service as a driver for that period. I have rendered that service, and therefore, my lord, it is a fault of the department, my lord. It's not my fault. I appeared in the selection. I was selected. I was given an appointment. I joined. I rendered my service up to from 2006 to 2014. Then, my lord, one fine day, my lord, you said that no, that was wrong. Okay, mistake was committed by them. I serve as a peon, but why shall I not get the, my lord, pay protection for that? Because now the fixation, if it is goes back to 2006, my lord, that's a hell of a lot of difference of the salary, my lord. I have been used to a particular, my lord, amount of salary there, my lord, lowly paid government employees. And my lord, it goes down and this will affect not only my this service career, but my lord, his pension also. And my lord, if the mistake was done by some authority, my lord, what action have you taken against that authority? I did not claim that I should be appointed as a driver. You utilize my service as a driver.
Lord, the plain and simple issue herein is that whether you can claim salary of a driver after getting appointment or after getting selected for the post of peon, my lord. It was an absolute illegality which has been cured by the impugned order before the learned single judge, my lord. It's an absolute illegality. Whatever be the consequences, my lord, whatever the injury he has suffered, that's a different thing altogether. But illegality cannot be perpetuated by.
So you have done the refixation in terms of this order?
My lord, illegality is on by them, my lord. I have not committed any illegality. Illegality has been done by some authority there. What action have been taken against them? Your decision. I did not ask for it.
Then we will dispose of this matter.
There is no infirmity in the single judge's order, my lord. Absolutely no infirmity.
Fixation has been done, isn't it?
Yes, yes.
You filed an affidavit showing the fixation.
To that effect, my lord. Yes, fine. Fine.
But my prayer was, my lord, that refixation part, my lord, that was the, but then they have already.
Then after that, maybe we'll have to hear the matter.
Then I'll pray that your lordship will fix it for early hearing, my lord.
Okay, heard Mr. M.K. Chowdhury, Learned Senior Counsel, assisted by Mr. K. Sharma for the appellate, Learned Counsel for the appellate. Mr. H.K. Das, Learned Standing Counsel, Guwahati High Court, submits that the pay scale of the appellate has been refixed in the
In the post of peon.
In the post of peon, with effect from?
That is the date
30/10/2006.
30/10/2006. Stop. And he prays for 1 week time, 2 weeks time,
2 weeks time.
2 weeks time to place the same by, before this court by way of an affidavit.
My lord.
Stop. Praise the Lord. List after 2 weeks.
After 2 weeks. My lord.
14.
Now in this matter, an affidavit. तो तो रिकॉर्ड आ नहीं सुबह बोल के नहीं मतलब in this matter, an affidavit was filed by the
Respondent, my lord, copy was served on Mr. Gupta on Friday, my lord, and the evidence are on record.
No, no, you are the appellant.
I am correct. My friend.
It doesn't matter.
No.
Sometimes it happens.
Not so that the affidavit was filed, my lord, last Friday only I have received, my lord. We'll file a reply to this one.
Okay, Mr. H. Gupta, Leonard Counsel, CGC, appearing on behalf of the appellant submits that the affidavit in opposition filed by the respondents 1,20,21,55, 68, 59, 93, and 114 was received only on
Friday, my lord. Friday.
on 27 September, and therefore praise for filing a reply to the same. Stop. Praise allowed. List after 2 weeks.
My lord. Okay.
18.
This is the one final.
This will, I think this will require time because it's a termination where I have been terminated from the service. I was a contractual employee. From 2005, I was appointed. And 2013, I have been terminated. Now, the learned single just said that termination in respect of contractual employee, there is no question of giving an opportunity of hearing. That's the main issue. And the inquiry was done behind our back. And ultimately, there was some finding. And contrary, there is a judgment of this court by a learned single judge where he says, even in a contractual or temporary employee, the principle of natural justice has to be followed. And there is a judgment of the apex court. There is a judgment of the apex court also in this context. So I think this needs an interference by this court. Court has fixed the matter for final disposal because the person is out. Only a chance should have been given to justify. That's our whole case.
It's going to take some time.
There is a very short point, but I don't know whether the Lordship is willing to take up. It's a very short point involved. Whether in a contractual employee work for more than 19 years, whether he requests a notice, the principle of natural justice has to be followed. Now, that's the point.
Supreme Court in some cases.
That's the issue whether Lordship will hear this matter. Some urgency was there, but it's up to your Lordship. You feel that it should be taken after you. It's up to the court panel. Short point, which is covered by judgment of the Supreme Court also. I found one judgment of the Supreme Court. Para 30 of the judgment.
Yes.
Yes. That's another aspect. Only what is the single bench said, your Lordship cannot, but that's will hamper my future employment in another place. That's the whole case.
have come. They had issued a notice to you.
Yes. No, 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 no. No, 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 nothing, nothing. That's a whole case.
May kindly see paragraph 10,
There is no notice issued.
103.
Sorry, there was a provision in the agreement
Yes.
which permitted them to take recourse to such a.
But even that was not under challenge. Notice was the only issue.
That they have taken. Now, Mr. Das, even if we look back and say all these actions were bad, we can't put you back.
So that's another aspect of the matter. I don't want to be put, your lordship, that's a difficult tough for your lordship, put me back into service. But no, there is another point. With the learned singles, another coordinate message decided. Why it is required and for what purpose it is required. Keeping back into my service and another aspect of the matter. Copy code. Kindly see one paragraph of the judgment. Kindly see one paragraph of the judgment, my lord. My lord will kindly see page 9. As the exact on a similar issue, it has been decided. My lord, see page 9. See first second paragraph. It is no doubt correct that in case of contractual engagement, terms and conditions of contract would govern by the service condition employed. In the present case, contract agreement signed by petitioner does not have a clause permitting termination of contract any point of time if the services rendered by contractual staff was not found to be satisfactory. However, what is to be noted here in a bare presence of the impugned order of termination demonstrate on the face of record that the same was issued on the basis of finding of the inquiry proceeding conducted behind the back of the petitioner, wherein it has been projected the petitioner was guilty of misconduct. Therefore, the order of termination of service of petitioner dated 30/10/2021 is not only based on allegation of misconduct, but same is also stigmatic on the face of record. In other words, the impugned order of termination dated was founded on allegation of misconduct. However, the petitioner was not given any opportunity of being heard in the matter. Therefore, it is a clear case where the respondent acted in violation of principle. Now, next paragraph, my lord will kindly see next. That's important. The order of termination from service issued the petitioner the trapping of an order of dismissal removal from service. Therefore, such an order could not have been issued without giving the employee an opportunity of being heard, even if the same pertains to a temporary or a contractual employee. This is for the simple reason such an action, besides causing serious prejudice to the interests of the employees, would also have a bearing on the prospect of his future employment. That's the case, my lord. That's situated. Here, my lord, kindly see, he was reinstated in his service.
Lordship will get that in the petition, Lordship. But before that, Lordship, this is a judgment, Lordship, where I was also most probably appearing, and this is a case where no criminal case was there.
We have, there is an agreement. Page 85 is the agreement.
Lordship. Page 85. 85, Lordship.
85. I have annexed in a rate petition. Clause 6, kindly see mine. Clause 6 at page 85. Clause 1 is during the period. Well, kindly see clause 1 first. Termination is during that period. Not we say anything contained the service of party. The party is found guilty of any subordination or misconduct or of any breach of non-performance. Where is that you have given a so-called notice to me? Establishing this fact that there was a misconduct. And kindly see the affidavit.
My lord will kindly see page 80. Kindly see page 80, my lord. Page 80 of the state. In the first paragraph, it is pertinent when the GMC authority has conducted a detailed inquiry and thereafter GMC authority terminated 3 number of employees engaged by GMC. However, read petition was an employee under so and so services were terminated. It is also pertinent to mention has already inquired the entire incident, which also includes the conduct of the petition. In that view of the matter, even if a fresh inquiry would have been ordered in regard, in respect, that would have resulted in the same outcome. That cannot be, my lord. Any opportunity. Now then, the question. I'm sorry. Yes.
Clause 6, clause 6.
Clause 6, clause.
Page 85.
But my lord will kindly see the judgment. Single judge judgment also. My lord, at page Paras, lordship is drawing attention to page 9 of the judgment of learned single judge, coordinate bench, second paragraph. It is no doubt it is no doubt that in the case of contractual engagement, terms and conditions of contract would governed by service condition of the employer. In the present case, a contract agreement signed up by petitioner does have a clause permitting termination of the contract. Does have a clause. At any point of time, the service rendered by contractual staff was not found to be satisfactory.
Satisfactory service, they can.
Yes.
This case. But here, there's one to be on your side.
No, maybe, my lord, maybe signed. But principle of natural justice in a case of contractual will not be followed. Then what will happen to the judgment of the Supreme Court? Let's see the judgment of the Supreme Court, how it is being dealt. The apex court has been dealt. Paragraph 14, man. Paragraph 14. It could thus be seen. Lordship got it. It could thus be seen the communication said university said that the appellant contractual period had expired. In the facts of the present case, it would be revealed the services were discontinued on the account of allegation made against him by the dean of the said university. Since even according to the said university, though the employment was contractual, but the employer was entitled to get all the benefits regular employer. We find that in the facts of present case, appellant services could not have been terminated without following the principle of natural justice. We therefore find that the present appeal deserves to be allowed on the short ground. But even in case of contractual employee, if you have done the inquiry, principle has to be followed. I will satisfy my lord. Let it come after vacation then. If let it come after vacation, then I will satisfy. I think this is a ground where lordships, I think it has been discussed by the apex court also. I find that even in a contractual or a temporary, at least one chance should have been given. And this employee from 2005, 19 years, he is in service. There was an inquiry which has been conducted, my lord. Inquiry conducted behind my back, everything. A notice would have been given. From 2005, I have been working. Up to 2000, kindly see that, my lord, 2005 till 2023, I have been working. And in one stroke of pen, you have terminated my service. At least that chance would have been given. Now, my lord, the Honorable Justice Nair has pointed out that what do you say on the last part of that portion, that the view of the learned single judge to the effect. Today also, what we decide, back square what, whether you can be reinstated into the service. That's what your lordship has put a query. Reinstating of the service, that is the second aspect of the matter. First aspect of the matter, whether I should get a notice. That's the only aspect of the matter. Reinstate, of course, mine. First, whether I'm entitled to get a notice. That's the first. Second will be whether I'm entitled to get my service back. That's a different question altogether. That's what the view of the learned single judge. That it is a useless, it will be useless to proceed because you cannot be reinstated. This is second aspect. First, the first point A, whether I am entitled to get a notice in this type of case. That's the first point. Second point is, my lord, whether it will be useless to adjudicate the matter because once whether you can be reinstated in the service. That's the second aspect of the matter, my lord. First, whether I am entitled to get a notice or not. Lordship will examine this matter at one after vacation also. Lordship can take up. No problem.
That I'm fine. I was underlined. Yeah. Okay. The non-request made by Mr. D does.
Sometimes.
Junior counsel.
We also know, my lord. Somebody was asking. I said, no, as a lawyer, we also know to what extent.
For that. We'll list it after Puja.
Yes, yes, of course.
Sir, what's up message? It's only the judges who don't know what is happening.
No,
That's it.
judges, well, that's why I said to Honorable Chief Justice, somebody I said, some bench, why you are saying anything? I said that what is most important, one of the topmost lawyer, I find Mr. Doctor is no more. He used to say always, one case I remember, just sitting behind back, and I was just trying to say, keep quiet, see what they are discussing. This is very important. What the judges is having word themselves, you should notice. So your lordship has pointed out, this is what I have marked. Your lordship has said, yes.
My mic is on.
No, that's what I think that's the best part, that a lawyer has to watch the judges. No, we don't have always a good case. We'll always have this way or that way, my lord. And nothing personal. That's why I said, when I just joined, it's nothing with this case. 85, I joined my profession. First case, Mr. James Chaudhary, my own uncle, he said, okay, I'll take you to the district court. That was a criminal court, session court, one bail matter. He was given 100 rupees, I remember. You come along with me. That time we know James Chaudhary is one of the topmost lawyer. We went before district court. I was assisting him. Then, yes, Mr. Chaudhary, what case you have? This is 438, my lord. I think this requires, I think this is a fit case. No, Mr. Chaudhary, will not allow. We'll call for case diary. Why interim bail? No interim bail. Then he came out. Then I was sad for at least 3-4 days. I didn't talk with anyone. He called me in the chamber. He said, what has happened to you? Why you are not speaking to anyone? No, that day you moved the matter. No bail was granted. That's my first time which I accompanied. He said, you will not be able to practice. First lesson, don't identify with a client. It is only a brief. So don't think that always judges will be in your favor. It's up to them. If you really agree, go before the higher court. That day I learned that don't identify with your client. That's only your case. It's not that always some result will come this way or that way. So normally I tell the lawyers also when they go outside, don't identify. This is nothing. Judges may say a lot of things, but you have to accept it. If you are...
It's not in the context of this case.
That's what I'm saying. I'm deeply obliged.